Can nominees be legal entities?
Yes, they can. A legal entity can act as nominee director or nominee shareholder of a company if there are no legislative restrictions for that in a particular jurisdiction. In the case of a corporate nominee, its individual directors, also nominees, will act on its behalf and sign documents. Appointment of a legal entity as nominee has its pros and cons. One of the drawbacks is a more extensive and, consequently, more expensive set of documents that are requested for legal entities by banks or partners, constitutive documents. Regularly updated certificates, good standing, incumbency, etc., and documents for individual signatories themselves. A clear advantage, though, is a greater stability of the structure. You do not have to change a director if an individual nominee decides to change his place of work or country of residence. Besides, there are usually several individuals acting on behalf of a corporate nominee, so the signing of company documents will not be delayed by a person's illnesses or holidays.
For your information, manhunt for nominees. The UK trust industry has long held a grudge against professional directors who provide nominee services at dumping prices and, as a rule, neglect due diligence. But end customers and service providers did not share the sentiment and willingly used the services of such directors. It is this anything goes attitude and low fees that made the institution of nominee services an essential characteristic of the offshore industry, and by the late 1990s the number of directorships held by some nominees reached tens of thousands. The key place in the global market for nominee services has always belonged to Sark, one of the Channel Islands, located west off the coast of France, with a population of 550 people. Sark is the last feudal state in Europe and has long maintained an archaic taxation system that allowed at least half of the island's inhabitants in the late 1980s-90s to provide nominee services to the global, offshore industry in one way or another. In 1999, Sark introduced licensing for fiduciary services, similar to UK trust law. Residents of the island actively involved in the nominee business, who did not want to be licensed under strict English trust law and be regulated by the Financial Services Commission of neighboring Guernsey, in whose jurisdiction Sark falls, left the island and scattered around the world in search of states with less or no regulation. So, over the next 15 years, the UK nominees who fled Sark conducted their activities from Cyprus, the United Arab Emirates, Nevis, Mauritius, South Africa, etc. Manhunt for Nominees is the name we would use for a series of journalistic investigations in late 2012 that aimed at giving coverage of the activities of nominee directors, mainly British citizens formerly resident in Sark. These investigations were followed by articles and television reports, with hidden camera footage, in eminent English media such as The Guardian, BBC, etc. The nominee services were depicted in a very bad light because the journalists focused on the fact that, although legal, these services are used in committing various offenses, usually tax ones. This caused a huge public outcry and disapprobation. As a result, many nominees fearing negative consequences resigned, quickly winding up their business, and some nominee service providers ceased their operations. Several nominee directors faced criminal charges and were sentenced to imprisonment. The industry suffered significant damage and after these events markedly shifted towards traditional, centuries-old trust relationships, abandoning pseudo-trust instruments, which nominee services in fact are.